Okay, now it's recording. Anyway, I will let him introduce himself a little bit more than what I can do, because I know a lot about him, but not enough. Thank you so much for coming tonight. And give me ideas also for programs in the future. I have a speaker for October. I don't have a speaker for September, because I'm trying to get someone who has not responded to my emails and phone calls. But anyway, we'll come up with something. And as you know, we moved the library, so now we normally would have a program there, but people told me, I think you're going to have a good crowd, so you better be in the fellowship hall. And fortunately, the youth ministry usually meets here on Sunday nights, but they're not meeting here tonight. So they said, you can have it. I said, thank you so much, I appreciate it. The food, of course, you know, I tried to do something related to the program, more or less. You have a meatloaf, which is a mom's meatloaf. And it's not my mom's meatloaf. I have my mother-in-law's meatloaf, which is very good, but I got it on the internet. And then the potatoes, I thought that was a very interesting recipe that I thought, you know, I would try it. It's, I didn't put the names down, but anyway, that's, what is it called? Cottage potatoes. But the dessert you're going to get is Death by Chocolate. Which I thought was very appropriate for the theme. So that's why I made Death by Chocolate as a dessert. And you have some fruit, a fruit salad as well. I hope you'll enjoy it, but most of all, I hope you'll enjoy his presentation, because he's very good and he has a lot to offer. And he's ready for questions, so feel free to raise your hand and ask him whatever questions you have. At any time?
Anytime.
At any time. Okay, it's yours.
All right, thank you. So, as was just said, this is intended to be an open forum. I'm going to talk, but you're going to get bored of me talking the whole time. So by all means, ask questions. Stop me if I say something that doesn't make sense, because it's probably likely that somebody behind you or to your left or right has a similar question. So go ahead and shout it out. You know, if you want to raise your hand, that's fine, or you can just shout it out. Start talking over me. I really don't care. You're not going to confuse me, most likely. You're not going to throw me off track, so just go ahead and fire the questions. One thing I will say as we start, just to be clear, because I get this question a lot. I'm an estate planning and probate attorney, okay? I'm board certified by the Texas Board of Legal Specialization to do just that. That's what I do all day, every day, and I've done that for about 25 years. What I don't do is I don't do guardianship work, and I'm not a family lawyer. I don't invest your money, and I don't do what I'll call elder care type planning. So essentially trying to avoid our state, the MERP claims, Medicaid reimbursement claims. So, but basically anything else in the estate planning field you can think of, we do. And that's going to range from very basic, everybody needs a will, right, type of thing, to really, really sophisticated estate planning. And so that really runs the gamut. I mean, there's charitable planning, there's charitable trusts, there are trusts for descendants, there's partnerships, there's limited liability companies, there's private foundations, donor advised funds. There's just a ton of stuff in this area, okay? What we're going to talk about tonight is essentially some of the basics. All right, I think I styled it estate planning 101. What happens if, why it's important that everybody has a will, what happens if you don't have a will. And I'm going to go through some of the things even before I walked in here, and within 2 minutes, one of you in here, and I'm not going to name him, Eugene, came up to me and said, hey, what happens what happens if this happens? Then somebody else walked over and said, hey, is it really important for me to avoid probate at all costs, right? What's that all about? Those are some of the things we're going to talk about, because I get asked those questions all the time, okay? All right, so the first thing we're going to address is what happens if I die without a will. That's called dying intestate, okay? You don't want to die intestate, okay? Everybody in here needs a will, even if you don't think you do, and even if you don't think I have that much to give away, it's not that big a deal, you need a will. If you don't have a will, let me just say, it's going to be more time consuming and more expensive for your heirs to deal with your estate. Every time, without question. I'll explain a little bit more why that is. So you want a will. Okay, So the first thing is, what happens to my assets if I die and I don't have a will, okay? The first thing you have to do in that scenario is determine the character of the property. Everybody in here is familiar with community property, right? Generally know what community property is. You live in a community property jurisdiction, so I hope so. So when I say character, I mean the property's either community or it's separate property. It's got to be one of the two if you're married, okay? And why do I have to determine the character of the property if I die without a will? Because if I have a will, I could just say all my stuff goes to A, B, and C. Pretty easy, right? Or however you want to set it up. If I don't have a will, then we have this complicated set of rules in the estates code that lays out what happens and where your property goes. And the first thing we have to do is go determine character. So you can go back and see, why is it more expensive if I die without a will? Because if you have a will, I don't have to determine character. I can just follow the terms of the will. If you die and you don't have a will, I've got to determine the character of that property first, okay? So, separate property generally is things maybe that you were given, that you inherited, that you owned before marriage, things like that. Most everything else is going to be community property. All right. One thing I get asked a bunch is, well, what if it's in my name? Remember, with community property, title is completely and totally irrelevant, right? I earn a paycheck, my paycheck gets deposited into an account in my name. My wife owns half the account. It doesn't matter if her name's also on the account, if it's a joint account, if it's solely in my name, it doesn't matter, that account is still community property. So when somebody dies without a will, we've got to go figure out what every single asset is before we can figure out where it goes. All right, community property. If you die and you don't have a will, where does your community property go? The first question is, do you have kids? And if you have kids, are those kids also the kids of the surviving spouse? Okay? If the decedent dies, has kids, and those kids are also the kids of the surviving spouse, then all of the community property goes to the surviving spouse. Probably what you would think would be the answer. But if the decedent has kids that aren't also the kids of the surviving spouse, then where do you think the community property goes? All of it goes to the kids. None of it goes to the spouse, right? So blended families, big deal, right? So a couple of examples. Decedent husband was married to his wife for 40 years. They've got a $4 million brokerage account. They've got 2 kids together. The husband had a kid from a previous relationship and he died without a will. $4 million community property account. Wife keeps her $2 million. The other $2 million goes to the 3 kids. Surviving spouse probably a little bit shocked and not thrilled about that outlay. Okay? But think about this. Flip the order of deaths. If you flip the order of deaths and wife died first, she has 2 kids with husband. Husband had a kid from a prior relationship, but that's irrelevant. So her kids are also his kids. So if she dies first, the whole $4 million account goes to the husband. Right? So even depending on the marital relationship, you could have a different outcome depending on what spouse dies first. Okay? So that can be very problematic. Now, if you have your accounts styled in a certain way, then the intestacy rules might not apply. So if that same account we were talking about was held joint tenants with rights to survivorship, that's not an asset that passes pursuant to the intestacy rules. That passes by operation of your contract with the bank, and it pass automatically to the surviving spouse. And these rules will not be applicable. Okay? So you can have different things set up at banks that might bypass some of these rules. These are just the default rules. So blended families, we definitely need to watch out there. The next thing that pops into my head when I think about community property disposition, I think, is the faulty presumption, right? I think if I asked the majority of people on the streets in Texas, hey, you die without a will, what do you think happens to your assets if you're married? They'd probably tell me they go to my spouse. And as you just saw in our example, that might be true, it might not be true, right? And then there's the legal presumption. In Texas, all assets of a marital property estate are considered community property unless one of the spouses can show by clear and convincing evidence that they're not community property. So you have a legal presumption that everything you own if you're married is community property. Okay? So a few years ago I had
Is there,
yes.
What does community
Okay, good question. What does community property mean? So, community property in Texas, you have this, Texas law doesn't define community property because it defines separate property, and it says everything we said that's not separate is community. So basically, separate property are assets that you would own prior to marriage. They could be assets that you received from somebody via a gift, even from a spouse, right? Or inheritance would be separate property items that you might receive. So inheritance, gift, and things you own before marriage are the three big categories of separate property.
Will it help if you are not very much of, I mean, as we, not like you know everything, but as we are learning, some of us, I think it's very important to put a beneficiary in the bank or wherever you are in order that they know, and you can tell that beneficiary how do you want to be distributed if you die before you think, you know, because sometimes you don't know when you are going to die. You can be older and die very old, or you are very young and you can die very young. So it's always good to take from that thing that you can use in the banks, maybe a beneficiary, right?
Yeah. So the point that was made is have accounts can have beneficiary designations to them, right? And that can be good. That can bypass probate. If you had a will, if I have a will that says I leave all my assets to my wife, and I've got a bank account that has a pay on death feature to my daughter, then when I die, that bank account goes to my daughter. My will does not control the disposition of that asset. So beneficiary designations on accounts can be good. You'll see why in a few minutes why generally I don't want most of your assets held that way. While that can avoid probate, I'm not worried about probate. And again, I'll tell you why in a few minutes. But most of the time, I'm going to tell you that I would rather those assets pass in a different manner to the beneficiaries. All right, I had a client a few years ago show up in my office. She was distraught. Her husband died unexpectedly. And we were going through this. One of the questions I asked and didn't ask it clear enough was, because I was asking it to her since she was in my office, and that was, well, do you have kids? And she said, no, I don't have kids. So I continued on with the meeting. It was halfway through the meeting before I realized I didn't probably ask that the right way. So I went back and I said, well, did your husband have kids? And she said, well, yeah, but he hasn't seen or talked to him in about 25 years. I said, doesn't matter, right? So you've been married for about 25 years, you said? And the presumption is everything's community property? And so she starts laying out all of her assets, and I'm like, well, those assets are going to his kids. And she was furious, and she's mad at me. So he wouldn't want that. It doesn't matter what he would want, right? He's no longer with us. He could have had a will and chose not to have it. So most of his assets went to his kids. We had to find the kids. That wasn't easy. Wife was so distraught, she'd argue with me a long time about different aspects of their assets, like her IRAs. She kept telling me, you don't understand, those are my IRAs. I said, tell me what you mean by they're your IRAs. She said, they're in my name. I said, when did you open up your IRA? Right? After we were married. And what money went in there? Paychecks went into contributed to my IRA. It's community property. So you're telling me that my husband's kids, who he hasn't seen in 25 years, get half of my IRA? Yes, they have your IRAs. And she goes, next thing you're going to do, you're telling me they have half my house. And I go, they do. So that was a giant problem and easily avoided. But you can see it can be an epic disaster if you don't have a basic plan in place. All right, we're going to move on to separate property. Separate property has an entirely different set of rules if you die without a will than community property does. Okay? Just like community property, it matters if you have kids and how your separate property is disposed of. But unlike community property, it matters not if those kids are also the kids of the surviving spouse. It just matters if you have kids. Okay? And unlike community property, whether that property is personal property, like your stocks, your bonds, your cars, or whether it's real property, there's a distinction in how those assets are divided. So just quickly, if you die with descendants, where does your separate property go? Your wife would get, or your husband would get a 1/3 life estate in your real property. What's a life estate? Nobody uses them anymore. A life estate essentially means that the surviving spouse is entitled to 1/3 of the income off of the real property, if there is any income, right? So if you own a home and you lived in it, there wouldn't be any income there. So 1/3 of the life estate in real property, the other remainder of that property goes to your descendants. Your wife gets 1/3, your spouse gets 1/3 of your personal property, so your stocks and bonds. That's your, again, we're talking about separate property. And 2/3 goes to your kids, okay? If you're married with no descendants, then your real estate would pass 1/2 to your spouse, no life estate, outright 1/2, and 1/2 to your parents, siblings, or their descendants, okay? Personal property then would go all to the spouse. Nobody comes in to do estate planning and does this, right? Nobody comes in and says, you know what I would like if I died? I'd like my wife to get a 1/3 life estate in my real property in Oklahoma. Right? This just doesn't happen, but these are the default rules, okay? Okay, why is it, now briefly going to talk about the administration of the estate and why we don't want to do this. It's more complicated. If it's more complicated, it's more time consuming. If it's more time consuming, it's more expensive, okay? We've got to classify the property. We've got to go to court, do an heirship proceeding. That's called a determination of heirship, right? You don't just get to say who your heirs are. The court has to determine who your heirs are. So we have to have a proceeding. We have to figure out who the heirs are of the decedent. A lot easier to do when we have a female who dies than a male. The court will appoint an attorney ad litem to represent unknown heirs. So not only are you paying the attorney to administer the estate, you're also paying another attorney that the court appoints to go figure out if there are any unknown heirs out there. We got to go through this whole process to figure out who gets all your stuff. Then we have to classify all your stuff, and then we have to distribute it, okay? If you die owning property only in Texas, well, then we only have to do this in Texas. If you own property, like real property, a lake house in Arkansas, we got to do this in Arkansas too. And their laws aren't going to be the same as our laws. And so you're going to have to do an ancillary probate proceeding in Arkansas, do another proceeding there, whatever they require, and figure out how their intestacy laws say your real property passes, okay? So you might actually be doing this in more than one state.
Sir, when you say about probate, that inquires, like you have to talk to a judge, and usually the ones that do the probate more expensive because it has to be dictated by a judge that knows how to do a probate. Not all the attorneys know how to do probate, right?
Right, so probate in Texas is super, super easy. We have something called independent administration. So if you die without a will, you're most likely going to be in a dependent administration. That is no good. Dependent administrations take a lot more time. They're a lot more, and that means they're more expensive because the administrator has to go to ask the judge before they do anything. If you have independent administration, it's just what it sounds like. I appoint my wife to be the independent executor of my estate. She goes to court one time. The hearing lasts for about 5 minutes. She gets appointed and the judge says, go forth and do what you need to do. And there is no coming back to the judge asking permission to sell an asset, distribute an asset, or administer the estate. It's all independent of court supervision, so it's very, very straightforward and very easy. So you can spend time on the front end, so I'll just dive right in since you brought up this question. Right, I get asked all the time, what do I need to do to avoid probate? Beneficiary designations, fund a revocable trust so that all my assets are owned by a trust when I die. Those are things you can do to avoid probate. But you are going to spend more time and energy doing that than you will if you just go through a probate in an independent administration setting. Okay? So I don't like to, as an estate planning attorney and a tax attorney, I do not like to accelerate costs, and I sure as heck don't like to accelerate costs I'm never going to have. So if you want to avoid probate, you have to do things like retitle your house, right? Maybe retitle your house into a revocable living trust. You can do that, but you're going to pay a lawyer to do that. I don't even know what the odds are that you're still going to own that house when you die. And if you don't own that house when you die, then you accelerate the costs you were never even going to have, right? But you're certainly accelerating costs. And so I generally don't tout avoiding probate at all costs, because it's just generally not worth it. Even if you move your house into the revocable trust to avoid probate, right? Because the idea is if you move your house into a revocable trust cannot die, right? So if you die, the trust is still there, the trust can't die, that property doesn't need to pass through probate. The problem there, though, right, is the cost up front doing that. You're going to get correspondence from the taxing authorities telling you that you lost your homestead ad valorem tax deduction. You don't lose it as long as the trust is a qualifying trust. But the taxing authorities don't know that, so you're going to have to deal with that, probably fill out more paperwork to get your homestead exemption back. It's just a lot more effort than it's really even, you're just not really avoiding the cost of probate in Texas. Is just not something to worry about. What I do want to avoid is a probate in another state, right? So if I had a lake house in Arkansas, I don't want to own that in my name. I want to own that either in some type of vehicle that avoids probate, like a revocable trust, or maybe some type of entity like an LLC, a limited liability company, something that can't die so I don't have to do any ancillary probate in another state. But as far as Texas is concerned, I'm just not worried about it.
What can you do if you are a person, like in my case, that I'm a widow, my husband died, and I want to put somebody that, in case I get sick, or something that he represents me, or give him all the authority to act on my behalf, in order, whatever I tell him to do, or distribute in case something happens to me between certain people. Can you do that?
Yeah, you should come up here and teach this thing. That's what we're going to talk about next. So yes, the question is, what can I do about, these are incapacity questions. I'm not dead. My will's, effective when I die. I'm not dead, I'm just incapacitated. If you're incapacitated, you need your incapacity documents in place to make sure all this runs the way you want it to run. There's various ways to do that, but your basic incapacity documents are your financial power of attorney. Somebody's making financial decisions for you. You can give them the broad authority to make financial decisions for you, or you can restrict them in some ways. I generally tend to go broad because you don't know what possibly could happen. And you're appointing somebody in that capacity that you trust to make the right decisions for you if you're incapacitated. So you get somebody in place to handle all your financial affairs. If you don't have somebody in place to handle your financial affairs and you become incapacitated, then you're going to need to get a court-appointed guardian to handle your estate. And you want to stay out of that at all costs. That's probably the most archaic and troublesome thing we have in Texas estate law is guardianships, especially guardianships of incapacitated individuals. You want to stay away from that at all costs because they're very time-consuming and expensive, right? So you stay away from that by having the power of attorney that says, if I'm incapacitated, then my sister, my brother, my son, my daughter have the right to make financial decisions for me, okay? You also have a medical power of attorney. That medical power of attorney lets them make all medical decisions for you. What doctor do you see? What nursing home do you get admitted to, okay? You can have something called a living will, or directed to physicians is what we call it in Texas. That's the document. That's sort of the pull the plug document, right? That's the document of I'm incapacitated, I'm not doing well, I'm expected to die, what do I want to happen in these scenarios, okay? If you have those documents in place, then if you become incapacitated, you shouldn't need a guardianship of your estate because you have somebody handling your money. And you shouldn't need a guardianship of your person because you have somebody that is in control of where you are, right? What facility you're in and all that stuff. So you can avoid those guardianships by having those documents. So as part of your basic kind of estate plan, everybody's going to have a will. Everybody's going to have those representative, I call them representative documents, financial power of attorney, medical power of attorney, director. Okay? That's your basic kind of estate plan. I usually do an estate plan that also involves the use of a revocable trust. That revocable trust you can think of as an extension of your will. They're made to be read together because they're basically one document. I could put everything in this revocable trust in my will. I just don't want to, okay? Because the will is filed of public record. Everything that's in there, nosy neighbors can go see what it says, And believe me, they do that, right? If you die, you're probably gonna get calls from random people. Like, why am I getting a call asking me to sell my house? Because somebody knows that you're the surviving spouse, okay? But people do go look at it. So I don't want to disclose any information in my will that I don't have to. My wills are real skinny because it has a pour-over provision that says everything else other than my home, my stuff, my TVs, clothes, personal effects, that stuff can go to the spouse, outright to my spouse. Everything else gets poured over into this trust, and the terms and conditions of that trust nobody knows about, so it's private. So my will is really skinny, and all the meat and potatoes of the estate plan are in the revocable trust. That also then allows me in certain circumstances to do things like retitle my Arkansas Lake House into the name of that revocable trust to avoid probate in Arkansas. It also allows me, if I have a client that is in the situation where they do want to avoid a probate, and their estate is just simple enough to where I've got 2 bank accounts, 1 brokerage account, and this. Can I just not retitle stuff into my family living trust and avoid probate? Yes, you could. So I don't say avoid probate by funding a revocable trust at all costs. What we do is we say, let's look at your situation. If it makes sense, given your age, your asset mix, and your objectives, maybe we would fund a revocable trust to avoid probate, but most of the time we don't. But it's there in case I need it or want it, okay? So that's how I plan those basic documents. All right, if you have minor, it doesn't look like most people in here, but if you have minor kids, that's another reason you gotta have an estate plan, right? Minor kids cannot inherit property, and then we have to determine who the guardian is, right? So if you don't decide who that person is, a court will decide who that person is. Better for you to decide who gets your kids than some random judge that doesn't know that you really secretly hate your sister, but that's who gets your kids, right? So you decide. If you don't decide, a judge will decide for you, right? So minor children have to have a will because you want to say who's their guardian, and they can't take property, right? So they can't. You're going to have somebody in place to deal with their assets. So you want to pass those assets in trust for kids and name a trustee to control those assets. Okay, so the next thing I want to talk about then in that regard is the use of trust in your estate plan. We sort of touched on revocable trust a little bit. And I think the easiest way for most people to see this is when you think about kids. It applies to spouses too, and we'll talk about how it does and why it does in a minute. But the easiest way for most people to see this is think about your kids, okay? You could have an estate plan that leaves all of your assets to your kids. And that might be simple and easy, and I'm going to tell you you should never do that, okay? No significant amount of wealth whatsoever should ever go to your kids. It should go to a trust for your kid's benefit, right? Why would I want to give the assets to my kid and then have to worry about what happens with those assets at my kid's level, right? My kid gets a divorce. Are those assets going to be subject to, you want to leave it to your kid, you don't want to leave it to the divorcing spouse. If you just give it to your kid, those assets can get commingled up with other assets and easily end up with the divorcing spouse. They could easily end up with a judgment creditor, right? Your kid gets in a car accident or something and gets sued. If they own the asset, it's not otherwise exempt under Texas law from a judgment creditor, it can easily be taken from them. If you put that asset in a trust for their benefit, nobody's going to get it. The only person who's going to get it is the kid, okay? If you've got kids with good heads on their shoulders, they know what they're doing, and you trust them to make the right decisions, name them as their own trustee. They're the trustee. They decide what to invest in. They decide how to consume those assets, but they're protected. I would never want to inherit any amount of assets of significance whatsoever in my individual name for a whole host of reasons, and those are just a few of them. Just put it in trust, and name me as the trustee, okay? And I get to decide what to do. Because when you think about it, the kid is never going to take the money out of the trust unless they are going to consume it. And when I say consume it, I mean spend it without anything to show for it except for memories, right? So if I need to take $5,000 out a month out of my trust to augment my monthly living expenses, to pay for groceries, utilities, and gasoline, or go on vacation, okay. Tell me another reason I take money out of the trust other than that. I wouldn't, right? If I'm going to invest the money, I'll invest in the trust. If I'm going to buy a second home,
I'll buy it in the name of the trust. If I'm going to buy a lake house, I'll buy it in the name of the trust. If I'm going to invest in a small business, I'll invest it in the name of the trust, right? There's no reason to take the money out of the trust unless I'm going to spend it with nothing to show for it. If I'm accumulating any type of asset, the trust will do it, right? So kids that have inherited funds that know that you're comfortable with, you can use trust for a whole bunch of different reasons. Again, if you have kids that maybe can't handle this on their own and they need somebody to help them, they need a third-party trustee. But if your kids know what they're doing and you're comfortable with it, then just pick the age at which you think it makes sense for them to be the trustee. You've got younger kids, maybe you want to wait until they're a little older. 30, 35 years old before they take over their own trust is kind of a standard age frame. But yeah, leave assets in trust for the kids. Nobody is going to get those assets, okay?
Sir,
Mm-hmm.
I'm sorry. If you at a certain age, like 80 or over 80, sometimes people think you cannot think anymore, that you're an older. But if you present that you are still having a license and that you continue studying and it's for the Texas state, then you can prove that you're still in good shape, right? That they can take in consideration your opinion for doing legal things, right?
Not really sure.
Part of the
I understand the
government
question.
works that, because many of the people here are still not 80, but sometimes when you get to 80, they sometimes think that you don't have a good way to decide things. But if you prove you're still studying for the state of Texas and you still have licenses that approves it, that tells them that you are still active in your mind and everything, so they cannot say, we cannot take in consideration whatever you say. Or how can you protect yourself with that?
Okay, so I think the question you're asking is, I'm getting older, how do I protect myself against maybe kids or somebody else coming in saying mom doesn't have capacity?
To the Texas laws, because in Texas, they have different laws than other states.
Mm-hmm.
And so your expertise on that, how can a person that gets to a certain age protect and the government can say that whatever you say is the law because you are still active mentally?
So that's a good question. So it is really hard for individuals like kids. Those are usually the greedy ones who come in and think mom or dad is dissipating assets. They don't know what they're doing. They should stop spending this money because I get it when they die. Those are usually the people that come in and say mom or dad doesn't have capacity anymore, right? And they want to take the control away from mom or dad. That's hard to do. It's very hard to do. The reason for that is they don't have access, for example, to your doctors, right? The doctor, unless you're incapacitated, isn't talking to your daughter or your son about your mental acumen anymore, right?
But if
So-
you have good doctors that are considered good doctors, they have the right to say that you are in good state of mind.
Yeah, you could have your doctor write a letter that says you have capacity, right? At your annual visit every year, right? You go to your checkup.
Or longer.
Yeah, so you can do that. You can, but if a child wanted to argue that you didn't have capacity, they would have to, you didn't consent to letting them take over, right? Then what happens is that they would have to file a court action against you to get you declared incompetent, right? That's going, if you have capacity, the judge isn't going to declare you incompetent. If you don't, and you might lose that battle, right? But the judges are not going to say you're incapacitated unless you don't know what's going on. Age doesn't matter. You can be, I had a client several years ago who had a debilitating disease to where he was in a wheelchair and he talked incredibly slow. But you could understand him. It would take him about 10 times as long to say what I'm saying, but he could say it. He just had to be patient and listen to him. And his kids wanted to take his authority over his control over his assets away. They were not successful in doing that because he knew what he was doing, right? So it's not easy to do. It really isn't easy to do. I do get asked the opposite of that question sometimes, which is, I don't want to do anything foolish when I get older and dissipate my funds. Can I just give all that control up now before it happens? That's really hard to do too, because who wants to do that, right? You don't want to give up control over your assets today, because you might at some point in time have dementia and right? It's a fine line between when you start feeling yourself maybe have some mental decline and turning things over, right? That's taking the keys away from mom is the hardest thing to do, right? So all the time, taking the keys away is the hard thing. But if you just have to walk that line, and if you want to turn that over before you get to that point, but you don't want to turn it over before then, right? And there's really...
I had the experience when I used to live in one of the best buildings here in Dallas. That's how I came here with my government of Mexico. They put me in the best apartments that were Preston Towers. And I learned that so many people of the kids never got to see the parents. But when they were very sick, they came to see what were they living there of money. They just wanted their money. And in cases like that, people that are older, they can protect themselves. Before that happens, like you as an attorney can help them get arranged to keep their lives, and they leave it, not because they were the kids, leave it the things to them. Then they can leave it to the church or to whoever they want, and you can make those arrangements, right?
Absolutely.
Yeah,
Yeah, there's no forced inheritance in Texas. There is in some states, there is not in Texas. So you are not required to leave your assets to your kids if you don't want to, although most of your kids will think they're entitled to them, right? So you don't have to. But if you don't, they might sue your estate. You don't have to. But it is, question I get asked a ton is, how do I stop the heirs from suing or challenging my will? And the answer to that is you can't. Because you can insert in your will a provision that is a no contest provision that says whatever you did give them, if they contest your will, then they might lose that. But Texas law allows any individual to contest a will if they do it in good faith. And the burden for good faith is so low that if a child says, I don't think mom had the capacity when she made this will, I don't think she knows what she was doing, a judge would be very hesitant to say that the kid did not have good faith in bringing that lawsuit, so there's very little risk of the no contest provision being enforced by a court, which means there's almost no risk to the beneficiary in suing. There are some people that have a mindset of what you should do is, if you want to disinherit a kid, is to give them something as a carrot so that they will be mindful of this and say, well, I don't know if I want to sue, because if I get nothing, I've got nothing to lose. I don't really subscribe to that theory, because that carrot's got to be pretty big, right? If I had a $10 million estate and I gave a kid $100,000 as the carrot not to sue the will, but they're one of 2 or 3 kids and they're going to inherit equally, that's probably not enough. That carrot's going to have to be much bigger. And the reality is, if somebody sues, the beneficiaries, the legal beneficiaries, most of the time are going to settle with that individual. It's just economics. They're not going to spend $2 million to have a lawsuit if they could give the person $1 million to go away. So it is very possible that some of your assets would go to somebody you did not want to get, and there's really no way you can guarantee that it does not happen, right? Because as long as they're legal, as long as they would be entitled to it if you didn't have a will, right? I couldn't come after your estate because I would be entitled to your assets if you didn't have a will, right? That would pass pursuant to the intestacy rules we talked about earlier, and I'm not an heir of your estate, but kids are, okay? So I have some very wealthy clients that will come to my office every year to execute their will. It's the same will they executed the year before, which is the same will they executed the year before that, which is the same one they executed the year before that, right? Because if the kids say, I don't like this plan, and on some of these, they're not going to like the plan. Well, if I get to overturn your 2026 will, well then that means your 2025 will is valid, right? Because each one revokes the prior one. Okay, well now I gotta go revoke the 2025 will. You didn't have capacity in 2026? Now I gotta go prove you didn't have capacity in 2025. Now I gotta go prove you didn't have capacity in 2024, right? Either you didn't have, the ways to challenge wills are really twofold: capacity and undue influence, right? So either I didn't have the capacity to make the will, or I was unduly influenced by somebody else to put the will in place that's in place. We see that a lot with kids, right? Where one kid is caregiver for mom, and lo and behold, there's 4 kids, and the will, mom leaves all the assets to the one kid and cuts out the other 3. The other 3 sue and say that person unduly influenced mom to create this will, right? And they have to prove it, but if they can prove it, then maybe they can get that will overturned. But there's really nothing you can do to prevent 100% somebody from challenging a will, okay? Okay. I can keep going on and on and on. Does anybody want to talk about anything else? Anybody have any questions?
You mentioned briefly about beneficiary designations, maybe not being your preference. Could you talk about that a
Yeah.
little bit? Maybe on life insurance as well as on other assets?
Right. The reason I don't want beneficiary designations on life insurance that says, for example, my kids, or beneficiary designation on my brokerage account that leaves it to my kids, is for the reasons I said earlier. I don't want the money going to your kids. I want it to go to a trust for your kids' benefit, right? And you could have a beneficiary designation on a brokerage account or a life insurance policy that designates a trust for the benefit of your kids, but I generally don't want it to be the kids, okay? So the kids have all those benefits of having the assets in trust with really no downside, so why give it to them outright, right?
Can I ask, are there administrative costs to the trust?
Yes. If you have a trust, you do have to file a tax return, right? You file an income tax return. That's basically it. Like if I inherited $2 million, that money could go directly into my brokerage account, or it could be in a brokerage account and in the trust. I got to file a tax return for the trust. Other than that, I don't know what's in the trust, right? The brokerage account says it's in the name of the trust. Other than that, no impact on me whatsoever. I file a tax return and that's it.
Well, trusts have higher tax rates,
So trusts do have higher tax rates. They reach the higher tax bracket faster than individuals.
way faster, right?
Way faster than individuals, that is correct. But if I'm the beneficiary of the trust, and I'm the trustee, I have control of all that. If I decide that I want to take the income, and I distribute it to me, and then that income flows and comes onto my 1040, the trust gets a deduction, right? The trust files a tax return, it gets a deduction, it doesn't pay tax on that income shows up on my 1040, and I pay tax on it at my rates, the lower rate, right? So at me as the beneficiary would have the decision to make. Am I more concerned about paying a little bit less in taxes and taking the distribution, or do I want to keep the asset in the trust? That's my decision, right? So effectively, no change at all to the tax rates because I control if I want to. I control what tax rate I'm going to pay, right? You have a question?
I'm concerned about like the mass after you die, like say we want a series of Gregorian masses set for you. And I've been to masses where, for example, there's no rosary set for the deceased. Can you put this in there? And is there a way to ensure that like the rosary is being said or the money set aside for the Gregorian masses are said?
I don't know the answer to that question directly. I think I would communicate that with the church folks, right, of where you would want the mass, but you wouldn't want to put it in your will because you'd be long since buried before your will is probably probated and nobody would see that, right? You can have a separate standalone document that maybe expressed your wishes with respect to the disposition of your body or this ceremony that you want. And that's not uncommon. It's not super common, but it's not uncommon either. But you wouldn't want to put it in your will because, right, I mean, nobody would see that by the time you were buried. Yes, Betty.
How often do you have people review their will and trust and such? Did you say before you have people, clients who do it every year?
Those are people with bees for their money. Those are really, really rich people.
Yes. So how often do you recommend that?
I mean, normally it's every 2 to 3 years you want to look at your documents. The big things you're looking for is fiduciaries, changes in, you've appointed so-and-so as executor with your brother as backup executor, or this person's my healthcare agent and this is the backup. And then that person becomes incapacitated or dies, right? When you have people that are listed in your documents in a fiduciary capacity, and that changes, well, that should just trigger, let's change it. Other than that, every 2 to 3 years, you might just want to pick it out and look at it. And really, if you're not, and part of this depends on whether or not your estate is taxable or not. We do a ton of planning where we're trying to reduce or eliminate the estate tax because it's very, very punitive, right? It's a 40% tax. So, right, when I was probably I was practicing law for about 1.5 years, and I had this little old lady come into me, sat down in the office, and she said, this can be really easy, I know exactly what I want to do, right? I've got $10 million, and I want $1 million to go to each of my kids, $1 million to go to charity, and, the balance to go to charity, I think it was $1 million to charity, and the rest for her kids. She had 4 kids, and so she did all the math, and she's like, that's enough, they're good. And I had to tell her, well, they're not getting anywhere near that. Like, that's in fact when this federal state tax exemption was $1 million, right? Well, you're paying 40%. You don't have $10 million to give away. You have about 6 to give away. And she was floored, right? So we do a lot of planning where we're trying to reduce or eliminate that tax as best we can. If you're not doing estate tax planning to eliminate an estate tax, then you want your plan to be as efficient as you can from an income tax perspective, right? Because remember, when an individual dies, the beneficiaries get a basis adjustment in all the assets they inherit, sans a few exceptions, right? Like you don't get a basis adjustment on IRD income assets, income in respect of a decedent. If you get things like IRD assets, IRAs, 401ks, right? Things that are going to be taxable to you when you take it out, those do not get basis adjustments on death, but everything else does, right? Like you had a house you bought for $300,000, it's worth $500,000. Well, the beneficiaries get that house with a $500,000 income tax basis, so they could sell the house after you're gone, and they pay 0 capital gain tax, right? If you had a stock portfolio that had a basis of $1 million, but it appreciated $3 million, same thing, that stock portfolio gets a basis adjustment to $3 million. The heirs could sell all the assets the next day and pay 0 capital gain tax. Whereas if you sold them, you would have paid a 23% tax on $2 million, right? So most of the time, you're just, if you don't have an estate tax, we're looking for ways to make the estate more efficient from an income tax perspective. And
Sir,
usually-
are you talking about people that own a house, but it's not totally yours, that you still owe money, but you are paying your mortgages every month, like according to the law? And so you think if somebody dies, suddenly, that nobody expects that you're gonna die, then the person that gets the home that you put in your will, that you wanna go to this person, has to pay all what you owe of that house before they get it, right?
The house passes subject
Like
to
for
the
instance,
mortgage,
I
yes.
died today, and I didn't expect that to happen to me, but I went with you, and I put, for instance, my nephew that lives in another state, then to be the one that is gonna take over and be the owner. So he will have to have the money or sell the house in order he can pay everything I still owe on the house, right? In order it can be his house.
And 9 times out of 10, beneficiaries are going to sell your house and take the
You don't
proceeds.
need to make like you were talking before, a trustee, or you don't have to make a trustee better before it happens? Will it be better trustee that you were talking about?
Well, I
years
mean,
ago?
if your house was not owned in a trust and you owned it individually, right, then your executor would be the one doing what you're talking about doing.
Uh-huh.
Your executor would say, I'm going to sell the house and pass the net proceeds on to the beneficiary, or am I going to transfer the home subject to the debt to the beneficiary, right? Usually the executor would ask the nephew in your
No,
example.
when you're leaving everything on his name, and I said, like, if I trust you because you are my brother or my nephew, and if I trust you, and I know you good enough that whatever I tell you to do, you will distribute according to what I tell you back in person or in a written normal letter. I want that you distribute this between my nieces or my grandnephews or whatever. He will have to, and you have and you know that he will do it because he's a decent, nice person. You have to know the person.
Well, so I'm okay when we're talking about personal effects, okay? Most of the time my will is not listing every china set I have and my TV and my couch, and,
No.
right? You're not doing that. You're just leaving your personal effects generally to whoever you want, and they are dividing them up amongst themselves.
The value of the property.
Right, but what you can't, and you can leave a written memo to your executor saying, hey, I'm gonna have this letter here, and it's gonna tell you I really want that painting, or this watch, or that necklace to go to Susie, please do that. But the executor's not bound by that. And really, it's okay with smaller items, but really the executor would be, whoever gets the assets in the will is the one who's legally entitled to them. And so that person would technically be making a gift of those assets to somebody. If you left me assets and it was worth $100,000, but you said, I really want you to give it to Sally, right? That's really what I want. I'm just trying to simplify it. Right. If I gave it to Sally, I'd be making a gift to Sally.
No, just the value of the property. So sometimes you still owe money to the company that they also do the areas, the common areas. You owe money, well, you have to pay them more before you can really get out of there.
Yes, so your executor's job is to come in, get all of the assets, assemble all the assets, pay all of the debts, and then distribute the assets according to the terms of your will. And if they distribute assets to people before they do all that, they're personally liable for it, right? So if they take the money and they send it out to beneficiaries, and the beneficiaries consume or spend it, and then we look and we say, oh, you know what? Doesn't look like she's been filing income tax returns for the last 10 years. Well, the executor has to file your final 1040, and he, at that point, finds out you haven't filed tax returns for the past several years. Distributing the money out to other people is very problematic, right? So, that's what an executor does, but almost never are any of your homes going to be kept, right? Your heirs are going to come in, and they're going to sell it. If there's a mortgage on it, they'll pay off the mortgage with the proceeds and distribute the balance. But it's very rare that somebody's going to want to keep your house. They're just going to sell it and take the money. So your assets, whatever they are on your death or what's dispersed, we don't know what that's going to be. It could be your home and stocks and bonds, personal effects. But yes, unless you specify in a will that the mortgage is paid off, I could leave my nephew my house and it could have a mortgage on it, and I could direct in that disposition that the executors to pay off that mortgage with other assets if I had the liability, if I had the assets, so that the nephew got the house free and clear. I could do that. If I don't do that, and I just say the nephew gets the house, then the nephew's going to get the house subject to the mortgage. Yes.
So, Eric, do you recommend for a lot of circumstances to have his, hers, ours, assets defined in the document so that there's no question, can you speak to that?
Yeah, so if you have a situation where there's a lot of separate property, then you can agree. So spouses can agree, right, in Texas that their assets are community, even if they're not. Like I could say everything I have, I'm going to make it community with my wife, right? Even if a portion of that is separate property. We can also agree that this community property, which is this asset, which is community property, we can partition it so that we can agree that it's my separate property or it's my wife's separate property. So spouses can agree on whatever it is how they want their property to be owned between them. And if you have a situation where you've got blended families, right, or you've got his and her kids, or one spouse has kids, the other doesn't, and you have a significant amount of assets that could be separate property, a lot of times it does make sense to have these marital agreements that spell out what property is what. Because it changes all the time, right? And so it's hard to go back and trace. So if I had an asset that was my separate property, it's always my separate property. And as long as I can trace it, like I had Wells Fargo account XYZ, and I closed that account and moved it to Bank of America. And then I distributed that to this brokerage fund and I bought some piece of property with it. That's my separate property. But I'm gonna have to trace it and show where it came. So if I've got an agreement that's in place that's 5 years old that says this account's my separate property, and we want to deal with it down the road, I don't even own that account anymore. Where did that money go, right? So yeah, it's a good idea if you have that situation. A lot of people in this room probably just have community property and aren't worried about it. But if you do have separate property and you want to keep it separate, it's a good idea to have a marital agreement in place like that that delineates what's what. And updating that every once in a while, especially for changes in accounts, makes a lot of sense. What other questions? There's got to be more. You
You
have
have
another
the
one?
answer to everything, you know, it's your Bible for you.
I don't have an answer to everything. When I first started practicing law, a very astute attorney told me, I was in his office and he asked me a question and I didn't want to look like I didn't know the answer, right, as a young associate. So I acted like I was thinking about it. I really wasn't sure. And I answered the question. And the individual looked at me and goes, "Do you know that to be true, or are you just guessing?" I said, "Honestly, I'm just guessing. I'm really not sure if that's true or not. I'm not sure if I'm right or not." And he said, it's not what you don't know that's going to get you in trouble. It's what you think you know that you don't know, right? Like think I'm smart enough to go figure out most stuff, but if I think I know the answer when I don't, that's the problem. So I have no problem if you ask me a question. That's why I said fire them away. If I don't know, I'll tell you I don't know. I don't know the answer to that question. Yes?
I'm sorry, I was
Or,
a little late, so I don't know if
Yeah.
you were exposed like this. But can you talk about any complications on leaving money in the trust to your minor grandchildren or any minors?
okay, so two parts to that, minors and grandkids. And I'll take the easy one first, and that's minors. If you leave assets in trust, right, trusts don't own assets, trustees own assets. So you designate, for example, me to serve as trustee of the trust for the benefit of minor grandkids, right? So the trustee is the one who has legal title to the assets, right? So it's the trustee who's controlling that. So it's not the minors, they're just beneficiaries. So a trust splits the equitable title with respect to an assets that go into a trust between the beneficiary and the trustee. So the trustee can be the beneficiary. You can have one person in both roles, or you could have a bank be the trustee, a parent be the trustee for a minor, right? And the beneficiaries of the trust are your grandchildren, but the trustee is the mom or dad of your grandchildren, right? So the trustee invests the money and decides whether they should distribute any of that money out to your grandkids, right? So there's no minor issue with that. The minor obviously cannot be the trustee.
What about a situation where you are divorced and you would like one of the parents to have no say on anything? I mean, how can you maneuver that?
Yeah, that's actually really easy because if you have your son and he divorces his wife and you want to leave assets to their kids in trust, then you name your son as the trustee. You don't name wife as the trustee or ex-wife, you name son. So son controls. You can designate, if your son fails to serve for some reason, you can designate a successor trustee to your son, right? You might want it to be ex-wife since it's her kids too. You might say, no, don't want her to have any say in it at all. Well, then you name your son as the trustee, you name his sibling or friend or bank or some third party as a successor trustee to your son. You can easily set it up to where ex-wife never has a say in what happens, right? Only the trustee decides that. The grandchildren issue is a lot different, and if you're talking about making gifts of more modest amounts, you don't really have to worry about this, but if you start talking about making large gifts, you get into the whole different system of we have a gift and an estate tax system, gift and estate, and we have a separate tax system called the GST, Generation Skipping Transfer Tax. There's a couple people in this room that I know what I'm talking about when I say that, and most of you will just make your eyes roll in the back of your head of what's this GST tax. But it's literally a tax designed to stop you from sending your money to your grandkids in lieu of your kids. But the government doesn't want you skipping that generation because they want the tax at that level, right? So if you talk about making too big of a transfers, then you have this GST tax that comes into play. And it's a horribly punitive tax. It's another 40% tax on top of the 40% gift and estate tax. So you heard me right, it's another 40% on top of the 40. So if you were to make a transfer that was subject to this tax and you did not have any exemption to cover this transfer, you would be paying an effective tax rate of right about 100%. And the reason for that is not only is it a 40% tax on the gift, it's a 40% tax on the GST transfer piece of it, and then you get to pay a gift tax on the GST tax you paid, and it makes the effective rate about 96%. Yes?
Okay, so speak to annual gift tax exclusions and how you can pay directly for medical, education, all that, to institutions without that coming into play.
Yeah, so everybody can give gifts to anybody they want under something called the annual exclusion, which is now like $19,000 per donee, per donor, right? So I can give each one of my 4 kids $19,000 and I don't have to tell the government about it at all. If I give them $20,000, I gotta file a gift tax return and tell the government I did it, okay? But I can give $19,000 to anybody I want. You can also pay for things, like Jenny was alluding to, you can also pay for things like health care, college tuition. You can pay for those things, and that does not count against your $19,000 annual exclusion as long as you pay those things directly to the provider, healthcare provider, or the college, right? I cannot write my check, I cannot give my daughter a check for $19,000, and then when she goes off to college, say, oh, your tuition bill is 15 grand, and write her a check for 15 grand, deposit into her account, and tell her to pay the school. I can't do that. I would have to pay the school directly that $15,000, and then that doesn't go against that $19,000 annual exclusion that I can give to anybody. So you give $19,000 to anybody, and you can pay for things like health care and private education in college as long as you make those checks payable directly to the institutions or the providers. And those don't count as gifts. So if I don't answer your question or I don't get it what you were asking me right, just tell me. But if you have assets in a trust, right, you have a funded trust that has assets, the trustee would control the disposition of those assets. So not an agent under a medical power of attorney or financial power of attorney wouldn't control that, it'd be the trustee. Right? And your financial power of attorney, remember, is only effective when you're incapacitated. When you die, it's just, can you rip it up because it's no longer applicable, right? It's only effective when you're incapacitated and alive. So if you have assets in a trust, the trustee controls. You can provide all sorts of backstops on that of who the trustee is, who has the right to appoint additional trustees or remove trustees. But if you had a spouse that was the trustee and you're gone and they're the trustee of a trust and they start doing things that are not good, right? It might be in breach of the terms of the trust agreement, they might be committing fraud, but who's going to sue them? Kids? Going to sue mom? Right? So sometimes, you just want to, depending on the situation, you just need to walk through and decide who should be the right person to serve as trustee here. On Friday, I had a client come sit down in my office, and he was really trying to get me to let him give away all of his assets with no control over it. And I kept telling him I'm not going to do this. And he said, well, this is fine, I'm totally comfortable with this. I'm just not worried about that, and you're looking for boogeyman. I'm like, no, what you want to do is you want to transfer all your assets to this trust and lock it down to where nobody, in case he got dementia, nobody can change it. Nobody's ever going to be able to change it. You can't control it. I was like, you can get that, you can do that. I'm just not going to do it for you, right? Because that's a terrible idea. You're going to come back for me in a few years and you're going to say, why did you let me do that? I had a client 10 years ago who had a very close trusted advisor. He was a CPA. Trusted advisor. He left the trusted advisor in his will. In his will, he left him $2 million. Okay? Left assets to kids and everything, but the trusted advisor was getting $2 million. And his mom and his dad both had dementia. He was paranoid that was going to happen to him and that he was going to make really bad decisions. So he was recently married. He hadn't been married for more than 2 years when he came back to me. And he wanted a plan that said, newly married wife and advisor have to agree before he can change his documents. And he said, can I do it? And I said, you can basically do anything you want, unless it's void against public policy. And this would not be void against public policy. Great, so he can do it. Yes, you can, but I'm not going to do it for you. So I did not do it for him. He did leave this individual $2 million in his will, and probably it wasn't 2 years had gone by before he called me and said, hey, I want to take that guy out of my will. I don't want to leave him $2 million anymore. Which I thought was funny because not only would you have been stuck leaving him $2 million, you were telling me you weren't going to be able to change your documents unless he agreed to it. And I highly doubt he would agree to cut himself out of the will for $2 million. So you can only, there's a lot we can do, and we can incorporate some things that are probably over and above this discussion. We can include concepts like trust protectors. We can get other people into the mix if we need to maybe make some changes and have like additional backstops. But there's only, at the end of the day, there's only so much you can do. And certainly if the trustee wants to commit fraud, you're just going to have to sue the trustee.
I have a tax question.
Okay.
If you have a relative and you place in your bank account POD payable on death to that individual, is there a tax benefit of not doing it that way and keeping it in a trust, or does it work out the same?
So your question is the tax benefit. So if you had a POD account and you had $100,000 in account POD to a relative, right? The individual that bypasses any type of probate, bypasses the terms of your will. So if you had estate administration expenses that were eating up a part of your estate, for example, that asset got to the beneficiary outside of all that. So that beneficiary would get the $100,000. Okay. If it's cash, there's no tax consequences whatsoever, right? If it was a $100,000 account that owned stocks, then as we said before, because it was includable in your estate, they would get a basis adjustment on those assets, so they could sell them and there'd be no tax. So from an income tax perspective, it's nothing. If you wanted to leave those assets into a trust for the benefit of the individual instead of giving them to a POD, you said, I don't want to give it to you outright, maybe it's too much money, how about I leave these assets in trust for your benefit? The same answer from an income tax perspective, it wouldn't change. They would just now be the beneficiary of the trust that held that asset.
So, we have our daughter as the state. So, but she's moving to another country. So if something happens to us, is that something that would be difficult for her to manage from another country?
That's a great question. So I will tell you that I would recommend that you put the person in charge of your estate who is the best person to do that regardless of where they are. If they don't live in Texas, even if they don't live in Texas, they could live in another country or they could live in Oklahoma, which is like another country. If they live in Oklahoma, right, what happens? If they're the executive of your estate, they're going to have to get, they can live in another country or another state. They can still serve as the executor of your estate here. They just have to have somebody appointed locally for service of process, but that's no big deal. So they would just have to get, because they're not a Texas resident, they would have to have somebody, the court would say, who do we serve, who gets served on behalf of this person if somebody's going to sue the estate. So they just need some resident agent, which is usually a service at that point. We would use a service to do that. And there are companies that do that. But yeah, just who's the best person to do it? A lot of stuff can be done online. I mean, you can transfer billions of dollars with the click of a button. Advisors do that all the time. That's super easy. Cleaning up your house, getting ready to sell, disposing of your personal effects, that's a little bit harder. You know, your daughter would probably have to come here to do that. She could hire a real estate agent and never come here. Right? She could have a friend go to the house and clean it up for her and get ready to sell and take all the personal effects out of it. So it can be done. It's generally easier if the person's here, right? For those reasons, especially with hard assets that are right here, it's easier if somebody's actually local. But if she's the one to do it, if she's the person you trust to do it, she's the person that should do it, then it doesn't matter if she's in a foreign country.
I have a question right there. Mentioning, like, for instance, you have a property that is not totally in full pay, or if you deal like with one of the best companies in Dallas, at least, I don't know if in Texas, but in Dallas is Abbey Holiday. And it has a very, very good reputation with the woman died at 103, and it was wonderful, the business she handled it. So everybody that works for that company, they have to have very nice qualifications to be accepted. So then if you have a property and you give it to somebody, I'm not saying to them, but somebody of that category, you give your property to them and they can sell it for you, clean the house for you, everything, that's more valid to do it that way, right? Because you are giving to somebody who's going to handle it right.
Yeah, it's the executor's job to decide who that person is, right? The executor's job is to hire a realtor to sell the house, whether it's Abby Holiday or anybody else. That's the job of the executor. So the executor doesn't actually have to do it, but they say who gets to do it, right?
But I hired you as an attorney in what you do to see that everything goes right, that you have a backup of somebody else that knows more than the person that is trying to do that business.
Yeah, the executor, so we represent the executor of the estate. So my job is to help the executor in that scenario administer the estate. We take them to court, we get them appointed, we do the things that we have to do from an administration standpoint.
So it's better that way, right? It's better that way than as you are mentioning right now. To hire you, besides that you have the company.
Well, yes. So if you passed away and you named somebody as the executive of your estate, they're going to need a lawyer to advise them on what to do. And whether that's just probating the will generally and getting appointed, they're going to need a lawyer to do that. But then from there, they have to know what they're doing. And most people don't know what they're doing, so they need the help.
The correct person to help.
Would I be the correct person to help? Sure.
That's good to know.
Yeah. Yes.
If a military person who's a resident of Texas has a will prepared by a military JAG officer, does that carry the same weight as a will that's prepared here by locally here in Texas?
So the question is that a will was prepared by a military attorney for a military individual, right? And most of the time it's still going to say this person, when they're not in the military, is a resident of X, Y, or Z state. But as long as the will is valid, right? As long as the will is signed with the formalities it needs to be signed in wherever they are, then if it's like in Texas, it's have a valid will in Texas, you gotta sign it, right? You don't have to date it, but we date them. You sign it and you have witnesses, witness your will, and it's notarized. You could write it all in your own handwriting, and then you don't need witnesses, right? That's called a holographic will, but don't do that. But generally, that's what if as long as it's valid, then it would carry the same way here. So I could probate my will in Texas. If I needed to, I could probate it in another state. I might have to take some additional hurdles if they have another requirement that I didn't meet for whatever reason. So in Texas, we have something called, it's attached to your will. You sign your will, and then you also sign something called a self-proving affidavit, where the witnesses that would be required, this is why probate in Texas is so easy, the witnesses that would be required to be brought into court to say, yeah, we saw this guy sign his will. We were there. He seemed competent to us, and he was over 18 when he signed it. Right? The witnesses that would have to come to do that in the hearing, they're doing it beforehand. They're signing this thing called a self-proving affidavit, and they're acknowledging those things the day you sign your will. So I don't need to go find them and drag them into court. Right? It's already done. I have the will. It's valid on its face. I probate it. And it literally takes 5 minutes to have a hearing and probate a will unless there's problems with your will. All right? So if you go to an attorney that knows how to do it, you're not going to have problems with doing it. So it works just fine. Yes?
Okay, so I'm surprised you said that people come in every 2 to 3 years. We only come to every 5 years. No, I'm doing on that. If anyone has a will that is older than what number of years, do you think they should get reviewed?
Yeah, I mean, so usually, like I said, when I do documents, I'll send out what I call a closing letter, and it tells the people who just signed their wills, here's what I want you to do now. Like now that you sign this document, I want you to, here's how your life insurance should be, the beneficiary should be styled. Here's how you should style your beneficiaries of your 401k or IRA. In that letter, I usually say, again, it makes sense to revisit this every 2 to 3 years. And part of that depends again on fiduciaries, or if the tax laws are changing and we know that something significant is happening, then maybe that's a reason to look at it. But there is no. Somebody asked this actually before this started, and I have a really old will, and age of the will doesn't matter, right? If it's valid, it's valid. It doesn't kind of go away. It's too old. We can't probate that will. It's from 1972, right? No, it's still good, but every 2 to 3 years just makes sense. You might, and that review just might be, yeah, this is still the disposition scheme we want. This is still what we want to happen. There's nothing major that's happened that would change this. Then it might just be something as simple as that, right?
Sir, you just mentioned something. Is it good to have, everybody should have a life insurance?
No, I don't think everybody should have life insurance. I'm not a financial planner, but if you want me to give you my 2 cents on that, I will.
So what would a life insurance would
I mean, life insurance, there's about 100 different things life insurance can be used for, right? In its most simplistic form, it's used for income replacement, right? I have a term policy on my life because if I drop dead tomorrow, my wife needs the money to raise our 4 girls. But if I'm to the age and the net worth where I don't need that income replacement anymore, then why am I paying for insurance? There are other people that use insurance policies from an investment standpoint, which is not necessarily inherently wrong. There's a lot of people that will invest money in whole life policies and universal policies and things that build up a cash value because they do that under the insurance wrapper of the policy. Policies aren't taxable, right?
About something difficult because the home insurances, you have to really have a bad case before they give you anything, it's not worth it.
Well, look, my father-in-law, when I got married, made me read The Millionaire Next Door book. I don't know if anybody's heard of that, but he made me read that book. And that was one of the things they talked about in the book is, who needs life insurance? Like, what do you have life insurance for, right? There was a single person in the book, and she had life insurance. What's the single person have life insurance for? What are you trying to protect against? What are you doing? So again, I have life insurance that we use to buy out cross-purchase agreements, buy-sell agreements, income replacement. I've got special needs kids. I've got millions of different reasons why I might want insurance, but just in general, should everybody have life insurance? No, I don't think everybody needs life insurance. Yes?
What would you advise for somebody that's coming to an estate planner for the first time, so that they know and are prepared before they come into the office?
That's a good question. So I always ask, do you have any documents currently in place? If you do, I'm going to want to see them. If you have any irrevocable documents that are in place, like irrevocable trusts or something like that, I'm going to want to see them. If you're a beneficiary of a trust, I'm going to want to see that trust. And then I want to have an asset, a financial statement, right? I want to see what your assets are, what type of assets they are, their real property, their retirement accounts, the personal residence, and what is it? So I want a list of assets with approximate fair market value and kind of those other documents I talked about. Those are the things I'm going to want to see. If you have life insurance, that's an asset. It might have zero value, it might have some cash value, but I'm going to want to see it. Right? Just so that it's kind of a comprehensive plan to make sure that all of it gets tied together in a way that makes sense.
Eric, where is the will kept so it can be found after you die? I have copies of mine, but the worry in the back of my head is, what if somebody robs my house when I'm on vacation and somehow that disappears? Or that worse than that, because there's a lot of information in that stuff. But what if the house burned down and the will unlit it, or some other way I lost it? Would the will copy that my attorney has be acceptable?
Gosh, I think I just talked about that with you, Gene, before. So, no. If you have, so the rule is if you cannot produce the will, that you destroy it, right? So I often get asked, how do you destroy a will? I don't know, you burn it, you shred it, throw it in the trash. There's a million different ways you can destroy a will. It's really hard for you to destroy all the copies of the will that might be out there, right? So Texas law has a presumption that if you can't produce the original will, it's because the testator revoked it, right? And you can overcome that presumption, and I have overcome that presumption numerous times, and one of which the lady was in a nursing facility. They moved all the stuff out of her house to move her into a nursing home, and they think it got lost, and this was like in a 1-year time period. If you could show there was a fire, things like that. But you don't want to overcome the presumption, because if you lose that battle, you can't overcome the presumption. Well, then you died intestate, right? So it is important to have the original will. I think I've had to do the lost will, prove up the lost will, probably 4 or 5 times. And we've always had a story, and we've always been successful. But just coming back later, when the thing that we see most often is somebody in my office, somebody died intestate, and they're like, there's just no way. Bill was just, that's not Bill. He was too straight away. He was an engineer, for crying out loud. That's how they do stuff, right? Like, there's no way he doesn't have a will. People die without wills all the time. And so people just can't believe they don't have one. So when they can't find one readily, they think, well, my son got lost, or he was at this attorney. You don't even know what attorney you went, your heirs wouldn't even know what attorney you went to 20 years ago. You don't even know who should I contact. So it's important that you have the original will. All of your other documents, the revocable trust, irrevocable trust, powers of attorney, copies work just fine. Will, you want the original. So you can either, like some firms, we do this sometimes, not all the time, but we will sometimes store in fireproof, cabinets, the documents, and I'll produce a receipt to you. So I'll give you a copy, I'll give you a digital copy if you want, I'll give you a hard copy if you want, but I'll also give you a piece of paper that says the original, these documents listed on this piece of paper are down at Eric's vault, right? You can have a fireproof vault in your own house if you have one. You could put it in a safe deposit box, but if you do that, you should let people know, your heirs know that it's in a safe deposit box, right? and which bank that is, where that is. But it is important to have it. But if you got robbed and you came home and I don't think the first thing you're going to do is be, oh my gosh, did they take the will? But if you get robbed and it is they took the will, right, then at least you'll know. And if your house burns down, at least you'll know. So those scenarios are things that you probably have time to fix, right? If either one of those things happen, you have time to fix that problem.
My question is this question. Let's just say someone created a will 20, 30 years ago, and they've been in a mess, and then they got like in this place somewhere, and they lost contact with the attorney that helped create it, and they're not sure if that attorney is still alive. And then let's say they just think that maybe they created a will that were writing, and let's say they verbalized. Would that be valid in court? Because it's a will that created.
Yeah, so if you think you have a will that you might have executed a long time ago and you don't know where it would be and you don't even know the attorney's name, you can, almost all wills, the very first sentence in the will says, I revoke any prior wills. So if you have you're not certain, then you can certainly just execute a new one today and revoke that old one, right? Because your one today revokes the old one. That's one way of doing it. You can do a holographic will if you're so scared that could be out there that you could say, I'm going to revoke all prior wills and here's what I want to happen. You could do that, but then I'd still go to an attorney. I would want to rely on my holographic will, which will likely mess it up, right? But you could still, a holographic will can still be valid and overturn one that you had previously executed. I've had people that sign holographic wills before, like, I'm going on a plane, we're going to a safari trip to Africa, I haven't gotten my, I know I was supposed to come in there, I haven't got it done. Can you give me something just quick and tell me that this is what I want to do if this plane goes down? I hate doing that, but I've done it. You can do that, right? I'll say, okay, I'm going to send you an email, you get a pad of paper, you write this down, and then you sign it, right? So you can do a holographic will, but you would revoke it. You just got to, if you don't know, just go to an attorney, get a new plan done, and it automatically will revoke the prior.
Oh, well, let's say that person had a situation and they weren't sure, but they just at the same time, they themselves prayed for it in China, and just went to somewhere to get another class. Would that go valid or that they need help with attorney?
Yeah. You can draft it. If you want to draft your own will, you can certainly draft your own will. As long as it's executed with the right formalities, it would be a valid will, right? You got witnesses, it's notarized. You can't sign a will and take it to a notary and say, hey, I signed this 2 days ago, notarize it. The notary is notarizing your signature. You need witnesses present when saying that they watched you do what you did, right? So as long as it's a valid will, you can do it yourself. Good. There's several cases where that does not turn out well.
Instead of making a will, can you deal everything to a bank? If you are not so wealthy, but you have more or less a good standard, can you do everything through the bank, or you necessarily have to make a will?
I'm not sure. When you say do everything through the bank, you mean...
Well, because you can put, like, we start since the beginning, your beneficiaries, right?
Mhm.
If it's one or two or whoever, and you talk to the bank, so you die tomorrow, the bank has already signed off the beneficiaries. So
If I had 2 bank accounts and a brokerage account, and that's all I owned, and I was living in a care facility or a rented apartment or something, right? If I just have 2 or 3 assets, and I don't want to deal with any of this, and I just want to leave it outright to my kids, I can have beneficiary designations on those 3 accounts that say they go to my kids and be done.
and that's it, right?
That would be it.
Yeah, but that's a
Mhm.
good way to do it.
Yeah. Just make sure we do beneficiary designations, right? So like the good thing about wills and the trust is you can then factor in contingencies. You can't really factor those in under beneficiary designation. Like you'll say, I'll leave this to my 3 kids, and if they all survive me, that's great, right? And if one of them passed away, what happens? To the other 2 kids, to the kid who passed away, to their descendants, like his descendants or her descendants? Like what's the contingency plan there? Just make sure that that's all tied up. If everybody survives you, that's probably okay. But even if you had a beneficiary designation that said to my 3 kids, and if any kid's dead, to their descendants, and then you died, and one of your beneficiaries wasn't alive, and it went to their kids, if any of those kids are minors, well, now you got a giant problem, because the bank's not going to give the money to the minors.
But there are some families that don't have any kids.
Yeah, if you don't have any kids, you can leave it all to All Saints, probably.
Well, that's a good idea.
The library will take it.
But the families were not like that. They said, yes, please, we receive everything.
Charity is definitely a good beneficiary.
He's going to tell you to come more often. Well, you are excellent. You are so good. I really appreciate that you
Thank
came.
you very much.
As far as me is concerned.
Earlier you said something about filing a will and then that's public knowledge.
Yeah, so if you die and you have a will, the will is filed in the court, right? It's filed for probate. So anything filed in the court is public record, right? So I could go down to the court and say, I'd like to see a copy of your will if I wanted to, right? And so that's why most of the time I want my wills to be really skinny and they don't say much, because like if I have trust for kids or trust for wife, right? A lot of people, we talk about trust for kids, and it's really easy to see that. It's just as much important for spouses, right? Most spouses are like, well, if I leave everything to my spouse, okay, so then they get remarried and leave it all to somebody else? Yeah, if you left it all to your spouse, they can, right? So we use trust for spouses for tax reasons a ton, and just because we want some control over where those assets are ultimately going to end up. And I don't want anybody picking that up and knowing, well, the terms of the trust for you are as follows. Like, nobody needs to know any of that. Yeah.
So what would be in the will? Say for example, like my spouse dies. So I have to go to court with the will, probate.
So like my will would
What's in
say,
there? That
my will would say who's the executor. So his will in that example would appoint you as the executor, right? And it would say you get the personal effects, because personal effects don't belong in a trust. And it would say probably if you have a house, that you can have the house. And it would say everything else goes to this trust over here. And the trust is, nobody knows what the terms of that are.
But I'm saying there's no trust. I'm just saying it's just a will.
Yeah, you can have a will, the will.
This is Texas, it's a community state.
Yeah.
But I still have to go through probate anyway, even though everything's jointly owned.
Unless it's jointly owned with rights of survivorship or pay on death, right? You have joint accounts that don't have a survivorship feature to them, right? So a joint account by itself is just a joint account with me and my wife. If that joint account can have rights of survivorship to it or not, and that you just check the box when you opened up the account. Most people don't even know what boxes they checked. But if it has survivorship to it, it's a joint account with rights of survivorship, then the will doesn't control. That just passed to the surviving spouse.
So what would be in the will,
So,
in probate, that everybody has access to? Obviously, if I did that with the banking, then people wouldn't know the banking, that would be private.
that's right.
So what would they?
So assets generally don't get listed in a will, right? Because you don't know what you're going to own when you die. Unless you might be giving away certain assets in a will, like I'm giving this watch to my brother. But by and large, most of the assets, you don't list assets in a will. So it's not that your assets are disclosed, right? It's just who's getting everything is disclosed. Right.
So some people just want to know that.
Oh yeah, yeah. You'd be surprised. You'd be surprised at what happens with who. There are a lot of nosy, what I call them nosy neighbors. Of like, well, what happened, right? So if I had a situation where my will leaves, a bunch of assets to a kid, or the will creates a trust inside the will, and the terms and conditions of that trust are there, right? Then the boyfriend of the kid or whoever, like, well, I can't get these assets aren't mine. But the trust says you can. Anybody can go get the trust because it's in the will. They know what the terms are. So I separate. And the way I tell people is just, it's basically one document. You can read it and think of it as one document, but they're separated for that reason. All the meat and potatoes nobody needs to see.
And also, I was going to tell you, I learned the other day from the banker, the managers, that when you want to make anything like we were talking about trust views and all of that, it's that you have to be sure that your husband or your wife was not in the military, because they respect a lot of that. Somebody has an account that is a military also. Then they have more respect to the account. Did you know that?
I've not heard that.
Well, that's good to learn something.
What happens to a joint with survivorship bank account, let's say, in a common accident? Both die at the same time, there is no survivor.
There is no
That's the
survivor.
family act.
Right. So Texas has a 120-hour presumption of survival. And so if you died in a common accident, nobody hung on in the hospital for 5 days after that. They just literally died at the same time. And it's a joint survivor account. There isn't a survivor, just like you said. And it would pass pursuant to if they had a will.
To the will.
It would go to the will.
Whoever was presumed that
Now,
died.
the question is who presumed, right? Is somebody had to die last. If both wills are the same, like leaving assets when both spouses are gone to the kids, nobody really cares.
Yeah,
If
that's
it
the
was,
same.
if your will left everything to your brother, your wife's will left everything to your sister, we care, honestly.
Yeah.
Yes.
So let's say if someone's a will and then something happened to the surviving spouse, the beneficiary, instead both of us die, and now that goes to the next heir, and let's say you have several siblings, and they decide to split everything 50-50. And then, but there's a dispute, and so at what point will the judge favor one side or the other? And they say that, no, maybe that person won't want to, they should get a higher percentage. Will it get to know exactly what's on the will, or will that be disputing on the siblings?
Yeah, if the will is drafted well enough, it should be clear what happens, right? Who gets what. If it is not clear, the executor could ask the judge, hey, I'm trying to administer this estate, and I don't know what this means. I can't, I've seen some of those where I can't follow what's happening. If that happens, you could ask the judge to help you interpret the will if you want it to be protected from liability of giving assets to the wrong person, right? But the will hopefully should be clear enough to you know who's getting what, right? And if there's ultimately a dispute, one heir says, I think you're reading that wrong, you're the executor, well, they can always bring an action against you if they think it's wrong. I should be getting X out of this, and you're reading this wrong, right? But the judges typically stay away from the intent. Like, it's called the four corners. They read the four corners. Words mean what they mean. And if you say something, we should be able to interpret what it says. And we're not reading into what I think you wanted to happen. Like, so there was a case a few years ago where somebody tried to do their will by themselves. So they did their will and they said they're leaving all of my assets to my sister. Right? So the lady left all of her assets to her sister. She had a brother, but she left everything to her sister. Then she said, if my sister's dead, I leave it all to my brother. So she clearly favors sister, right? Okay. So she had another sibling who predeceased her and left her assets. So now she had her assets and all these assets she got. But she did her own will, and what she did in her will was she knew darn well when she was filling out her will what she had. So she listed all the assets that were going to her sister in her will. Her sister got all those assets. And since she did it herself, we'll never know, but the will did not have a residuary clause, which says anything I haven't already disposed of gets disposed of this way. That wasn't in the will. So she had a will that left all these specific assets to sister, Then her other sister died, and she inherited assets and didn't change her will. So basically, she doubled the size of her estate. And her sister argued, well, her will is clear that all the assets are supposed to come to me if I'm alive. And then only assets go to brother. And the judge is like, no, the will is absolutely clear that you get all of these assets. And the will doesn't say anything about any of your other assets. So this was a case where you could actually die with a will and still die partially intestate, which she did. Because her will only gave those assets to her sister. And then she died intestate with respect to all the other assets, which then her brother got a 50% share. So the judges aren't going to come in and say, and I use that as an example, a judge doesn't come in and say, I think that this is what they would have wanted and meant. It doesn't work that way.
Sir, I think I heard a statement that what you were talking about. If somebody wants to, suppose you don't live in the same city, and the other person says, well, I will do whatever you want me to do, or state in that letter or that document, whatever you want me to do for you, so you can dictate all the things that you want to be done, and that they will take into consideration as city value, right?
Yeah. An executive can certainly hire agents and people to do things if they're not around to do them. Right? They could hire an agent to come clean out the house, get it ready for sale, and do all that stuff. Yes.
Also, I can say all of that, so in order he does it or she does it.
Yeah, you wouldn't spell any of that out in your will. You just, if you trust nephew to do this and nephew wants to do it, nephew does it. If nephew decides, I can't do that, I'm going to hire this group over here as my agent to go clean that up. I don't want to go down to Texas. It's 105. Let somebody else go clean out the house, right? You can go do that, and he can do that. Yes?
Do you have any advice if you had a friend approach you, not family, and ask you to agree to be the executor of their estate? What would your conversation with that person be?
And you always ask good questions. I've had spouses who really, this is a big issue for them, right? Where they've got kids and they don't want to pick one kid versus the other kid we got to pick the oldest kid to be the executive. You are not bestowing any type of honor on anybody by making them the executor. Right? You're actually, that's the kid you hate most. So you make them the executor. Like, it's a job. It's a thankless job most of the time. There's work involved in it. There's potential liability in it too, right? You can get paid as an executor, but most family members don't take compensation. They just do it. But depending on the complexity of the estate, there can be a lot to do. It's not fun. It's not easy. It's time consuming. Anybody called a bank recently? The lawyer's telling me I need the signature card or the account application on this thing. We need to know, did this account have survivorship feature or not to it? It's in joint names. Well, call Bank of America or Wells Fargo or Morgan Stanley and try to get a copy of that. You're probably going to be on the phone for a couple hours, right? At least. That's just one account. Like this, there's work to do. So, I mean, I would be an executor for a family member or a really, really good friend, maybe. But if it's just somebody casually, I'd say, no, thank you, right? Maybe ask a bank. You can always go to a third, we can always get a bank to come in, most likely serve as executor. They're going to charge a higher fee, but is not a fun job to do. You got a chance for more questions.
But you answered all of our questions.
Okay, well, look, we probably, you guys, you're at a church, so give to church. In 2026, you got this new little above the line deduction, right? Even if you don't itemize, you can get $2,000 cash if you're married to the church, and you get above the line tax deduction for that. So you take that. So give $2,000 cash to the church, you get above the line deduction, even if you do not itemize, and you're taking the standard deduction, right? So that's good. If you're a big giver to the church, in 2026, you're gonna have that new phase out to pay for that $2,000 that we're allowing everybody to deduct above the line. People that give a lot of money to the church are now going to be limited in their deduction because of that new 0.5% floor that we have, which is going to knock out the first 0.5% of your charitable deductions, you're not going to get to take as a deduction. So if you have like a $200,000 AGI, or adjusted gross income, your first, what is that, $5,000. Or, $1,000. So 0.5%, one half of 1% of 200,000 is $1,000, right? So if you gave $5,000 to the church and you itemized, the first 1,000 of that you wouldn't be able to deduct anymore. You'd only be able to deduct 4,000. If you don't itemize, but you're still a pretty hefty giver, then you want to think about different ways in which you can benefit from taking the income tax deduction. And there's different ways, strategies to do that. Function, you could say, I'm not going to give $15,000 to the church every year. I'm going to give $45,000 every 3 years if I have the ability to do that, right? And bunch it all in one tax year so you can actually get the benefit of the deduction, right? But if you take the standard deduction and you're just giving somewhat healthy charitable contributions, you might not be getting any benefit from those at all. So there's different ways you can slice that. Yes?
Did you say that you don't recommend a family member being the executor of the will?
No, I didn't say that. At least I don't think I said that. Family members are perfect people to be executors of your estate because, well, they know you and they'll agree to do it. What I said is it's not a fun job. You're not bestowing honor on the kid who you're telling to be the executor because they're going to get their other kids chirping in their ears. How come you haven't distributed the funds yet? And they're going to say, because Eric's telling me if I distribute you funds and then I find out I owe money, I'm personally liable for it. So I'm not going to distribute the funds until Eric tells me, well, why are you doing it? You're always answering to everybody else. It is not like what you see on TV, which is somebody dies and you show up at the mansion and there's a reading of the will. That doesn't happen. And people walk out with all the money, right? That's not what happens. There's an administration, there's a time period. I had a client that, don't ask me how this happened because I don't understand it, but they had a ranch in New Mexico. And the government did a controlled burn that was not controlled and burned down the ranch. But the ranch was worth 15 to 20 million. It's like a 5,000 acre ranch in New Mexico. It's worth somewhere between 15 and $20 million pre-burn. But our government, and our government decided that the ranch had paid out a claim through FEMA for $132 million for the ranch. So pre-burn, it's worth 15 to 20. FEMA says 132 million. So executor brother doesn't know what he's doing, and executor brother gets to 132 million, and he thinks I'll just withhold 10 million, and I'll distribute the rest out. And then I got involved, and we're trying to see if we can claw some of this back because this is a really bad idea. You just distributed out $120 million, right? If the government comes back and says we want some of that money, what happens? You're personally liable for it, right? And he tells me, no, this is income tax free. The law that was passed said it's not subject to income tax. And I said, yes, it's not subject to income tax. It's very possible it's subject to estate tax. Well, that doesn't make any sense. If it's not subject to income tax, how could it be subject to estate tax? It's the way the laws work. We have stuff like that all the time. Muni bonds, I don't pay income tax on, but if I have the muni bonds in my estate, I'm going to pay estate tax on them. So you're either right in that, at the end of the day, the question is, what's the value of that claim? It's all about value. He thinks it's worth $15 million. I said, that's one argument. Another argument is it's worth $132 million, and you owe about $50 million in tax. Right? So if you're wrong on that, you've got a giant problem. So we don't distribute assets. So your heirs are going to be mad, and they're going to be yelling at the executor, where's my money? Because they think they should have had it yesterday. And you're going to explain, I got to file tax returns for mom. I don't even know if mom filed her last income tax return. I got to make sure everything's squared away. And it's a process, right? Most simple estates can be administered within a year, but if it's complex, it can easily take 2 to 3 years. And if it's taxable, if somebody's paying tax, well, then it's going to take 3 years because you're going to wait for the IRS to tell you you're good before you distribute funds, right? So if it's a taxable estate, the heir should anticipate having to wait about 3 years to get assets. Yes.
You write your own will, like we're discussing.
All right.
Does it have probate to be processed, or can the family just process?
So that's a great question. So wills do not necessarily have to be probated. The Texas law does favor what we call family settlements, right? So you could have a will and the family can all agree, all the heirs can agree not to probate it if it makes sense. So every will doesn't have to be probated, but most are, because if you had a will, even if the heirs said we're going to agree to something different, well, how do they get the money? Like there was an account in your name. They don't get to go to the bank and say, here's mom's will. We decided we're not going to probate it. Give us her accounts. Right, the bank won't do it.
But if she had beneficiaries on it,
But then you would need to probate the will if all of her assets pass pursuant to some beneficiary designation, right? So you can easily, most of the time you're going to have an estate, some of the assets are going to be subject to probate, right? And some of them pass outside of probate, right? But it's very rare that you're going to have your estate where everything passes outside of probate, right? And again, for the reasons I said before, unless we're talking really, modest amounts where trusts just don't make sense. I don't need to have a trust for this, I'll risk it. Any significant funds whatsoever, if you got $250,000 going to somebody, why are you giving that to them outright? Put it in a trust, let them be their own trustee. There are a lot of other considerations there too. So some of my clients will go, well, my son's a doctor. Okay, well then you know how stressed he is about getting sued, and you're going to leave him assets and just increase his estate? Why don't you put it in trust for his benefit? Don't increase his estate. And if the kid might have a taxable estate down the road because they're doing really well, why you don't want to add to that? You can put it in a trust, and you can design the trust in a way that when your kid dies, it goes to their kids, and it's not taxable to the kid. Through that whole GST thing, which is probably. You don't have to, at the end of the day, you don't have to fully understand all of this, right? You just have to know, go to somebody who can walk you through it, get a plan in place, let them explain to you what they're recommending, why they're recommending it. If you don't understand, ask questions. When you're saying I should do this, what's the benefit of doing that versus this? Feel free to ask those questions, right? You want to understand this. Yes.
Eric, do you do wills and trusts for special needs kids?
I do, but I only do third party. I don't do first party. You know what I mean?
Yeah.
Yeah.
I don't know. Third party.
Sir, have you heard of this document that when you are in an emergency, you can do it through the mail as the electronic thing? It's called DocuSign.
Yes. I know what a DocuSign is.
How do you like it?
DocuSigns are, you can't DocuSign a will.
It's not a will.
Okay, well, you can DocuSign just about anything else. Your tax return, a partnership agreement, an assignment, a whole bunch of stuff.
Do you like that?
Yeah, I love it, because I can't ever send documents to clients and get them returned accurately, signed
But
correctly.
that's good, so that's practical.
Yes, very easy. There's Adobe Sign, there's a bunch of different ways I can send something where they sign
Yes,
electronically.
because my nephew is a very executive, he travels with bankers like Chase, not inside the bank, outside. And he has a lot of businesses, lives in another state. And he told me, sometimes to save time, do a document, so I didn't know what he was talking about.
Yeah, DocuSigns, when you do a DocuSign, you gotta make sure you keep, right, there's a way to authenticate that document, which people screw up a lot. Like I don't need all these extra pages on the DocuSign. What is all that? I mean, people throw it away. You need that. That's telling me when it was sent, how it was signed, and who signed it, right? It's all digital information. So you don't just want the DocuSign page that has your little fake signature on it, right? That you did on the computer where you say, yes, I'll take that as my signature. and that page comes, there's going to be additional pages if you want all that together, because that's the complete DocuSign document.
That's good, thank you so much.
How long has the 19,000 gift been in effect? Tax-free?
The annual exclusion's been around forever. It goes up, it's indexed for inflation at $1,000 increments, so it has to get over 19,500 before it bumps to 20, right? Before it bumps to the next level. And so, I'm not sure how long it's been 19, but it's, it started off at 10, it went to 11, 12, whatever now, I think we're at 19. And once the inflation gets us to where we get to 19,501, it'll bump up to the next 1,000. Right, so it's a great, people use that all the time just to give like kids, just this is money they're going to spend and consume, and they'll throw it out to them.
I think that happened just this past year.
And that's per spouse.
Per spouse, that's right. So it's per spouse, per donee. So if you had, I'll do the math easy, say it's 20,000, you could give, husband and wife could give one kid $40,000, right? So, and not follow your tax return. Because it's per donor or per donee. So I could give my oldest daughter 20 grand, and my wife could give my oldest daughter 20 grand.
You can give 20?
Or 19 times 2. Just say 20 to make the math easy. But yes, you can give it to, and you can give that to anybody. So technically, Bill Gates could avoid the estate tax altogether if he really wanted to, by just walking out and just handing $19,000 checks to every single person, just like I'm just throwing out $19,000 everything, right? You could do that. Other than that, he's either going to pay a giant tax or leave assets to charity. Assets are only going to family members, the government, or charity, right? And that's basically where it's going. If you don't have a taxable estate, then you don't have to worry about planning around that giant tax. If you do, then you obviously worked hard for it. You want to leave assets to your heirs and not subject to 40% tax.
So you can do it in increments or in one lump sum all the way up to 19.
Mm-hmm. Yeah, a lot of grandparents will fund like 529 plans for their grandkids or something like that. You can put the annual exclusion to that. You can actually pre-fund those for 5 years if you want. Do 5 years of annual exclusion gifts to the 529 plan. Last chance. Any other questions?
Thank you.
Thank you so much.